Hello and welcome to the Courthouse, your #1 legal talk show where we get to learn the law together in plain, simple and entertaining language. We've been talking about all that concerns you as pertaining the law, and we just talked about employees' rights. This week we're going to be focusing on the rights of employers. Do they have rights? Who are employers? You get to find out more after this break.
If we have to give you anything, then we have to give you everything. Lava Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and oh this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Lava Plus Channel 465 on Star Times.
You're welcome back. This is the Courthouse with me, Itohan Olomu-Agbodo, and this week we are talking about employers' rights. We hear about employees' rights, their benefits and the like, but who are employers? Do they have any rights, and are they guided by any form of law? This week I'm joined by Nobel Uchechukwu, and he is a legal practitioner based in Nigeria. He's also a notary public and is a principal partner of Noble Place Attorneys. You're welcome to the Courthouse.
My pleasure.
Okay, so who are employers? Let's start from there. Who are they?
Well, in simple terms, because the Courthouse is about making law simple.
Yes.
So we're going to make it simple as much as we can. An employer is anyone who hires another to do work. A defined work.
Okay, a defined work.
An employer could even be someone who hires a domestic staff, as simple as a domestic staff. You're an employer, for the intents and purposes of that definition of who an employer is. Anyone who hires, engages, takes on another for the purposes of doing work and who pays wages. You could call it salary. You could call it allowances. You could call it even per diem for the services rendered by that other person. Is an employer.
Okay, but you just mentioned per diem.
Yes.
You talked about making the law simple. What is per diem in simple terms?
Okay, that's when it has to do with just a daily token that you get for the work that you do. That's what that means.
Very interesting.
Yes.
So before we go into the rights,
Yes.
are these employers, are they guided by any form of law? Because as you said, I could even be an employer. I could just employ some domestic staff. Do I have any law regulating me?
Well, generally in Nigeria, let's restrict it to Nigeria. Generally in Nigeria, the law that guides employment is the Labor Act. Okay. The Labor Act is explicit. There are some other laws like the Employee Compensations Act. They are all related, but the labor law, the Labor Act guides it. And then there are conventions over the time and rules of court that have emanated from relationships of parties, over the years, that these all come together to make up what we call the gamut of the legal, system guiding labor and labor-related matters.
Okay, so it's like legal framework.
Yes, the legal framework. So when a particular issue comes up, then the issue will determine which law, governs that relationship. If it has to do with the compensation, the Employee Compensations Act, Industrial Compensation Act requires some certain things that ought to be done. There are obligations of the employee as well as the responsibilities of the employer. So that determines what happens. Then the common law system had been available over the years because Nigeria is a state that, we are one of the common law states. We grew out of the common law system. So the common law, the rules of court over the years, the common practices, the equitable rules have all been there. So it depends on the circumstances of each particular matter that determines what the court will do at that given time and the rule that governs the relationship. But generally, let us restrict ourselves to the Labor Act.
Okay, so now we're restricting ourselves to the Labor Act.
Yes, for now.
Under the Labor Act, what rights do employers have?
Okay. Employers or employees?
Employers. We are looking at
Employers.
employers.
Okay. It might look, if you're looking at the Labor Act strictly, it might look like there are no clear-cut provisions of the law in favor of the employers. But there are laws, there are rules, there are rights that emanate. You see, one of the Latin maxims, very old one, says, ubi ius ibi remedium. Where there is a right, there must be a remedy. Okay. Now, and again, you don't just have obligations without corresponding rights. You don't have obligations without corresponding duties. Now, if the employee has protection from the law, if the employee is protected, if there are responsibilities, if there are rights that have been accorded to the employee by the law, it follows just from those laws that the employer also has a right flowing from it. But there are a few, that are explicit according to the law. For instance, Section 6 of the Labor Act gives the employer a right to make deductions from the salary, from the wages of the employee. There are conditions that are, associated with it. Okay, where an employee, as an act of discipline, maybe has damaged something and there is something, there's a claim that comes, the employer has a right under this section to deduct that from his salary, from his wages. Okay. Is his right.
But must it be stated in the contract of employment?
Now, I'm coming to that. Okay. I'm coming to that because, the rights of the employer can either be statutory or contractual. Okay. Now, some are statutory, the ones that have been stated by the law. The rest are contractual, which you will find in the contract of employment. Now, let me deal with the ones that has to do, the few that are provided that has to do with that are clearly statutory. This Section 5 and Section 6, gives some rights. Section 17 also makes provisions, that gives right to the employer. The section says, if an employer has a staff, an employee, who is a member of a union and has consented to the membership of such a union, a trade union. Now, there are check-off, payments, levies that are deducted. Now, such deductions are not just contractual, they are statutory because the law recognizes that the employer should deduct those ones and remit. Now, under the Pensions Act, which is one of the benefits that the law had given to the employee, in that the employer is obligated to make provisions, certain percentage of your earnings, and reserve it to a chosen, I will use the word chosen, yes, a pension administrator that has been chosen by the employee himself. Now, that same law gives the employer the authority to also deduct the given percentage that the law has approved from the wages of the employee. So that is a right. It is statutory. Now, under the NSITF, Nigerian Social Insurance Trust Scheme, there's a 1% of the gross of the annual, salaries that ought to come, remuneration that comes to a worker, that by that law, the employer is determined, is expected to deduct that and make that remission to that agency of government. Now, these are statutory rights.
Okay.
Now, again, an employer, surprisingly, the law makes a provision that an employer can set up a shop in the confines, within the premises. Once he gets approval, he can set up a shop. So some people call it tuck shop. So you don't need to go far to look for what to buy. But then the same law says you will not force the employee to patronize such shop. But you have a right to set it up. So is it under that same right, under that same provision, that you find some government agencies setting up a cooperative shop, within their organizations, and then the workers are meant to patronize such. Now, these are some of the statutory rights that have been provided, but then the rest are contractual.
Contractual. So that you get to see them in contract documents, contract of
employment.
Okay.
Now, but again, apart from what you have in contract of employment, let me go into some other provisions that the law expects of the employee. Now, employee has got duties. There are 3 major duties statutorily provided that an employee has. And then these duties can be stretched to a very thin limit. Judicial interpretations over the years and in different jurisdictions in America it's been taken further than you can ever think about. But within the common law areas, it's been restricted to certain extent. What are they? There's a duty of fidelity. Under the duty of fidelity, it is expected of the employee. Well, we are dealing with the employer's rights. But I need to get into this a little bit so that I can bring it out.
Yes.
Now, under the duty of fidelity, an employee is expected to do his duty to work for the employer within fidelity, honesty, in the best of his ability and in the best of his performance. Now, if the law has a duty on the employee expecting you, one of the cases is you can't just go out and start your own business. A lot of people do it, and that is something we need to teach now. Some people take it as if it's their right that how can my organ not allow me to do something on the side? The law says you cannot. You are breaching your fidelity. So if you have an employer who is saying, no, you can't use my time to do your private business, he is purely within his right. So you see another right of the employer that is flowing from the duty of the employee.
Yes.
You have that duty. For instance, you can see something going wrong in the place that you're working and you don't inform your employer. You have a duty. It's part of the fidelity to inform your employer that this is what I observed and this is going wrong. Now that's a duty. Now, if the employer, this duty of yours confers upon the employer a right to demand that you perform that duty.
Okay.
Are you getting me? Okay. Now, you also have a duty to obey lawful orders. Lawful orders and instruction. Yes, the law is careful to say lawful. The act is careful. Because, if I employ you and I ask you to go and slap somebody, if you do, you're going to go to court for it.
Well, it depends. What if I'm trying to protect another employee and maybe I'm on behalf of the organization, I'm trying to protect.
Let me try to remember a case. There's even a
particular
particular case that came to the Supreme Court. I remember the name of the case, the case citation.
Okay.
That a soldier gave orders to somebody to slap, to a junior to slap. And when the matter came to court, his defense was that I'm acting under instruction of my superior. But what did the court hold? The Supreme Court held, you have your own brain, you have your own head. You cannot be saying, okay, what if the man sent you to go and kill somebody? If he sent you to go and kill your mother, will you say you're acting under instruction? So that's why there is a limit to, it has to be lawful instruction.
Okay.
Now,
so the third one?
Now, this is the second one. And then the third one, the due care, utmost good care in the
Duty of care?
Yes,
In
duty of care in the performance of the duties of the employment.
Okay, I know it's quite interesting and the charts has really been interesting and insightful. But I want to take a listen to our reports on the rights of employers, if they have any, and our legal nuggets. Of course, they have a lot of rights. We'll be right back. Stay with us.
An employer is a legal entity that controls and directs a servant or worker under an express or implied contract of employment and pays him salary or wages in compensation. The principal legislation governing employment issues in Nigeria is the Labour Act. The Act is mostly silent as regards the rights of employers, but they generally have the right to hire or fire at will. The following should be noted when it comes to termination of employment. The Labour Act provides for minimum notice periods as follows. Where the employee has been employed for a period of 3 months or less, either party may terminate the contract with a minimum of 1 day notice. Where the employee has been employed for a period of 3 months but less than 2 years, either party may terminate the contract with a minimum of 1 week notice. Where the employee has been employed for a period of 2 years but less than 5 years, either party may terminate the contract with a minimum of 2 weeks' notice. Where the employee has been employed for a period of 5 years or more, either party may terminate the contract with a minimum of 1 month notice. When giving notice of termination of employment contracts where the notice is 1 week or more, the notice must be in writing.
Welcome back. We've been having a very interesting chat with Noble Ochechukwu. He's a notary public and a legal practitioner, and he's been talking about the rights of employers. And he mentioned the fact that the rights of employers also flow from the duties of employees as well, like duty to obey lawful orders, duty of care, and duty of fidelity. We still have him in the house, and he's going to be talking more about the rights of employers.
Yes.
And looking at, you talked about statutory rights. Now let's take a look at some contractual rights that we readily see in some employment contracts.
Okay. Now, I want to say this and make this point. Most of what you find in the contracts of employment are actually bringing down to details some of these rights that we are talking about.
Okay.
For instance, the employer has a right to protect his invention, his trade secret, his customers, and sensitive information. Is his right. He can't throw it out. This is what makes him tick. Now, in the course of working with an employee, an employer will insert into his contract of employment some clauses to protect this right. For instance, an employer may insert a non-disclosure agreement.
Okay.
You are not to disclose every information or any sensitive information that came into your knowledge or purview while working. Some can extend it, and I advise that, depending on the kind of job that you do, some can extend a contract that binds over an employee to such an extent that even if you leave this employment, you are bound over not to use some of this information or some of this trade secret that you obtain from this. It is his right.
But is there a limit to that? Is there a period of time that that's binding over?
Now, if it is contractual, there's no limit. It is what you signed. That's why it's contractual.
So you signed in ad infinitum.
If you sign in ad infinitum, you're going to be there. But again, certain rules will come in. Even if it's an invention, if you bring in patent law into it, there's a certain number of years that a patent will last, and then it becomes open to the public. So if a patent has been maintained for like 50, 30 years, depending on some classifications, 50 years, if it's a medical invention, once it's 30 years, you throw it out. Any other person can make use of it. So you cannot then bind somebody over for an information beyond that time that another law allows you. Law is such an interesting phenomenon that it affects every other thing that we do. So one law affects every other one. So in contract, now one of the major rights of the employer is the right to hire and to fire. That's the best.
That's the first and most important we hear
They
about.
hire and fire.
at will.
I choose to employ who I want to employ. I choose the standard of the person I want to employ. I choose what is it?
You're sounding like an employer now.
Because I am an employer. I am not just an employer. I'm also a fellow of the Chartered Institute of Administration. So this is also one of my tough.
Yes.
Okay, so you set the standard. The standard is yours to set. He who pays the piper calls the tunes.
Exactly.
I'm paying you. What is wage? What is salary? Salary, wage is just the employer's understanding and qualification of the input that you make in the business. That's what it is. So if I determine that I'm going to pay you, then I have to see the input. Now that brings to another right. The employer has a right to demand best performance from the employee. Best performance based on the standard that he set. So when your employer comes in and says, look, you didn't do this thing right, some people just take offense. This my boss, you can never satisfy him. He has a standard. You are to work and attain the standard. You can fire your boss. It's called resignation.
Exactly. And I think that's why I tell a lot of people, if you're tired of the place, you're tired of the way things are done, instead of going as in against the standards like you just mentioned, walk away.
Now, do you know that the employer also has the right, this has been stretched in some cases in America, to demand that you must at all time work in the best interest of your employer?
Organization, yes.
You must. In the right of the employer to discipline, there is a corresponding right of the employee to be given fair hearing and due process. Once an employer has met this,
That's all.
That's all.
Finally,
Nothing
let
you
me
can do
ask
about
you
it.
about reforms that you want to see, maybe in the Labour Act or in the labour sector generally. What do you want to see? What more do you want to see?
Well, let me start with this one now. You know, your invite has given me a reason to look at this thing, you know, again. One of it is that, just like I stated in starting, that the rights of the employee are not straightened out. I want to see a Labour Act, you know, that is repealed, where the rights of the employer, you know, will be set as against the rights of the employee. So we don't have a lacuna, or we have a system, you know, where it is left to the interpretation of the court, and the courts can exercise discretion as they wish, and then you start going on appeal. So if these are straightened out, that will be fine. Then generally, I have had, you know, cases, you know, where companies that we represent as their lawyers, you know, having the casual workers and the casual, you know, coming in to claim the contract, the rights of the contractor versus the rights of the full employment, you know, employee. These are some of the areas that I would like some reforms, you know, to make it clearer, you know, within our labor laws. Some of these. There are such more really.
Quite interesting. Those two are quite insightful too, and I hope the government will take note of that, or those reviewing our laws. Well, we have another segment. It's called the Bar Book. And on the Bar Book, we share Latin maxims and their meanings, legal jargons and their meanings. I know you've mentioned quite a few. I'm going to stick to one of those you said. Anyway, well, let me let you go first. Your favorite Latin maxim.
You let me know the one that I've said in case I don't, repeat
okay,
it. I don't repeat
you
it.
mentioned Uberima Fide.
Yes, utmost good faith.
Ubi jus, ibi remedium.
Where there's a right, there's a remedy.
Okay, so which
That's the one. Okay, there's
two.
one that I like. In the case of Aro and Fabolude, a Supreme Court case, Justice Aniagolo JSC, as he then was, gave a very lead judgment, and then he used one Latin maxim that caught my attention from my days in the university. It is interest republicae aut si fini litum. It is in the best interest of the state that there will be an end to litigation. So I'm saying now to the employers and the employees, when you fight, please find an end to litigation.
Quite interesting. So me, I'll stick with Uberima Fide, and that's utmost good faith. You get to find out more Latin maxims in our Bar Book segment. Stay with us. Well, it's been a very interesting interview with Nobel Uchechukwu, a notary public and a legal practitioner in Nigeria. I want to say thank you for making our time to be here this week.
A pleasure.
I would like to see you again some other time, because there are a lot of things that you've not told us that we want to learn from you.
Well, law is a life.
I like when you put it.
Is living, is active, and situations come every day. And because we are in a system where we say the stare decisis, another Latin maxim you will catch me, that is following after decisions of, previous decisions of the court. Now, we develop a legal system that even where the statute is inefficient or where the statute has, spaces, lacunas, you will call them, not provided for, the court will make the provision.
Yeah.
So
cover up
every
every
day there's a new development.
Okay, quite
in the law.
interesting. We would like to hear from you. You can log on to www.loveoplus.tv to get updates. You can download our app from any of the mobile app stores. You have numbers showing on your screen that you can also send comments to. And we'd like you to send questions to those numbers as well, or email at info@loveoplus.org. I am Olomu-Agbodo. I say, don't just get mad, go get a lawyer. Bye for now.